continuing to look ahead to this afternoon, and when the Daytona Beach stabbing suspect, Jean Macean, is due in court for a hearing. He is expected to use an insanity defense in this case, as Fox 35's Morgan Parrish talked about with us just a little bit ago. Now, joining us live now via Zoom to talk about these sort of defenses is Jose Rivas, who is a defense attorney not associated with this case, but we appreciate you joining us this morning, Jose. Always appreciate your perspective and your expertise. So thanks for talking with us today.
A pleasure to be here.
So when it comes to these insanity defenses, can you talk about how these are used in cases? What sorts of circumstances that we see these kinds of things used?
Right. Well, prior to going to trial on this defense, the court has already determined that he's competent to stand trial. So we're past that stage. I know there were some issues whether he was competent or incompetent. Now, what the defense needs to prove, and it has to be through clear and convincing evidence, is that at the time of the crime, he had some kind of what we call mental infirmity, disease, or defect. And because of that condition, the defendant, in that case, did not know what he or she was doing, or the consequences. But if he knew also that the defendant did not know what he was doing was wrong. So in other words, we have what we call a psychotic break. And this is all about what we call a battle of the experts. But the psychotic break, so to speak, they have to sell it to the jury. And they have to determine whether when this break, he did not know the consequences of what he was doing, or did not know that what he was doing was wrong.
And so that's interesting that you mentioned the competency. So it is kind of different, because I think sometimes we think of when you hear pleading insanity or using an insanity defense that there may be something where they would not be particularly competent to stand trial. But what you're saying is those are separate, basically separate determinations and very separate sets of things that have to be proven.
Correct. The insanity defense is in what we call an affirmative defense. So the defendant or the defense has the burden of proof. It's on the defense to prove the elements. In this case, being that he did not know the consequence. Now, once he does that, then the state must prove that he's has proper sanity. Again, everybody, according to the law, everybody is presumed to be sane. So the defense is going to try to prove that it's trying to achieve what we call a not guilty by insanity. And then at that point, the burden shifts to the state, and they're going to bring experts. That's why we call it the classic battle of the experts.
And is there controversy over this? This is something that some states don't allow, as I understand it, or what? It's very rarely used, according to statistics in criminal cases.
My understanding in Florida, it's about 1% of the cases it's used. But there are a lot of beliefs in regards to the defense. It's a hard sell to the jury. But again, it's battle of the experts. At the end of the day, it's going to be a lot of psychiatric evaluations. The defense is going to bring a lot of experts. It's going to be contradicted by the state. And at the end of the day, it's the jury that's going to have to make that determination. And there's also this thematic, thing that, this insanity defense is kind of a loophole for criminals to get away with crime. Mental health illness it's true, it happens. So there's certainly, that's why the law allows for it, but it's not an easy sell to the jury.
What makes it difficult for the jury to buy that? What's the challenge for you as a defense attorney trying to sell the jury on an insanity defense?
Well, you got to realize that just because they were insane, or they determined that at the time, the jury needs to determine that at the time of the crime, that this defendant was, had this mental illness. So he could be at trial, and they can see this defendant acting, communicating with his attorney, and that's obviously going to affect them. It's going to say, well, he looks fine now, but they have to jump the bridge to be able to determine whether he was had proper mental capabilities at the time of the crime. Remember, in order to do this defense, the defendant must admit, or is acknowledging that he did commit the crime. So we already have that, on the state side, he admitted to doing the crime. Now it becomes what we call, battle of the experts, trying to prove to the jury that he was not in his right state of mind at the time of the crime.
Because of that initial step, like you said, basically having to admit that they did commit this this act. Does that make an insanity defense a bit of a risk in some ways?
It is because the jury, again, and the funny part is here, the jury's going to know, exactly what, how the crime occurred, and you have to, although he's admitting to the crime, so to speak, the state's still going to prove on how the crime occurred, just to show the intent, just to show that he was in his proper state of mind. Juries, they're not doctors, they're not able to, understand mental health. But again, that is the defense job, to bring in some experts who can put it down in black and white, very legal and very easy terms for the jury to be able to understand. But again, there's this systematic that thinking that just because you're found not guilty by intent doesn't mean you get to go home either. So that's also another scenario where we're going to have to address with the jury as well.
And so, what if that were to happen? Obviously, um, still a little bit away from a trial in this particular case, and that potentially happening. But if that were to happen, what happens if an insanity defense is used and the jury rules in their favor?
Right. If that's the case, he could be sent off to a mental health institution. And statistics show that actually people spend longer time in mental health institutions after being found not guilty by insanity than had they been sentenced to a regular prison sentence. So it's not like he gets to go home, and the jury's going to be made aware of that as well too.